Hi everyone, my name is Mitchell. I've seen faces here before. I've seen some of you before. Even though Jolly and her crew took a year off, they didn't miss a beat. So clearly they're still doing an excellent job, and I have to say that this is really one of the best special ed law conferences in the country. I think it's really good, and you're really fortunate, and I'm sure you're all in at Julie's presentation, and she's one of the best, and so what a wonderful way to start out a conference. But what I wanted to do today is talk about measurable annual goals, and why. Well, we all know why they're so important, but let me give a little background on myself first. I'm actually from Minnesota, although I'm now at South Carolina, so I've been there 30 years more. And so I'm quite used to the winters there now, which really aren't anything compared to your winters, and certainly not compared to Minnesota winters. And I'm a professor there in special education. My area that I work mostly in is legal issues in special education. But I want to emphasize that I'm an educator and I'm not an attorney, and what I'm saying, as Julie said in her opening, is not to be construed as legal information at all, but it's educational information drawing from what the law tells us we need to do. But what I want to do more than talk about the law is actually talk about how I think we can make certain that our goals meet the requirements of the law. And in addition to being a professor in special education, I'm also in South Carolina what we call a level 2 due process hearing officer. I believe Indiana was at one time a 2-tier state, but you're now a 1-tiered state, which means if your school district, if a parent sues your school district or requests a due process hearing, it goes to the state, and they have a hearing at the state level. And then, if the losing party wants to appeal further, that's when it goes to the courts. So, you know, in Indiana, like South Carolina, we don't have a huge amount of court cases, but we do have a lot of due process hearings. Now, I know Julie asked everyone, but I didn't notice. How many of you have been in a due process hearing? Okay, not a lot of fun. They're pretty horrible things to, not only expensive, they're emotionally wrenching, it's very difficult for people. I used to do that, but now what I do is level 2. So in South Carolina, we have what you used to have called a 2-tier system, whereas someone actually goes to the school district, there's a local hearing officer that's chosen and hears the case, and then if a party wants to appeal, they appeal to the state. So where yours would first appeal would go to the court, ours goes to the state. And I'm a state level hearing officer, which means I just, basically all I do is sit down at my dining room table with all the material from the hearing, the testimony, the exhibits, and those kind of stuff. And I just make a decision. Did the hearing officer apply the law correctly? And did he or she understand what the school district was doing? And I'll talk about this in another presentation later, but one of the things that I have found in doing this, in fact, I just finished a hearing a week ago, is that I can count on one hand the number of goals that are really measurable. And when they're not measurable, you can't collect real data on them. That's a problem. When you see that occurring, in fact, let me tell you this, in hearings, and David Bateman is another presenter here, he's done like 500 hearings. In hearings nowadays, that's the first thing attorneys go for, parents, is goals and data. They go to see, was there really data collected on these goals? And that's a very common thing. So we have to understand how important this is. Also, I've strenuously avoided these for the last few years, but I have been serving as an expert witness, because one of the things, and those of you in a due process hearing know this, is oftentimes these hearings wind up being a contest of the experts. Each side will have an expert, and they will testify. And let me tell you, if an expert can zero in on goals as not being measurable, you bet they will. That's right where they're going for, because that really goes to the jugular of what school districts are doing with respect to, can you really prove that students, your IEPs are reasonably calculated to enable a student to make progress. So that is basically who I am. And so we're going to talk about writing measurable annual goals. And we'll see how, there we go. Okay, the first thing, in 90 minutes, here's what I'm going to do. I'm going to start out talking about the procedural and substantive issues in FAPE and why this is important to understand. The next thing I'm going to do, I'm going to talk about the essence of the substantive requirement, which is writing measurable goals, collecting student progress data. So I'm going to change my glasses here. I have the wrong glasses on. There we go, that's better. Let me go on to the first thing, though. One of the things that's very important for you to understand is, how many remember PL 94-142? I remember it very well, because that's, in fact, I started teaching a few years after the regulations for that law took effect. Excuse me, I was a teacher in Minnesota for 12 years in special education. I started about the time the idea, or the then, it was called the Education for All Handicapped Children Act, EAHCA, normally just called PL 94-142, which means it was the 142nd public law passed in the 94th Congress. It's just a little shorthand way folks have of referring to laws sometimes. And so when this law was passed, one of the first things they did is, it's really, if you read the law, and I wouldn't know why you'd want to read the law unless maybe you suffer from insomnia and need a sleep aid, go to sleep with that, try and read that for a while, it'll put you right to sleep. But one of the major parts of that law, if you get through all the little procedures and things like that, is that we must, our charge is to deliver a free, appropriate public education to all youngsters with disabilities. And one of the original sponsors of the law was Senator Robert Stafford from Vermont, wrote in an article, 1978, he wrote an article for the Vermont Law Review, where he said, we didn't really define FAPE real clearly, but what we did is we created a baseline mechanism that essentially is a FAPE, and that's the IEP. So every case that in special ed that Julie talked about, or Jim Walsh will talk about tomorrow, or we'll talk about today, stems from what's in the IEP, because that's where it all begins. It begins at the IEP table. And thankfully, most things go well at the IEP table, and Julie talked about her 4 C's, collaboration, you know, and creativity, and all those, communication. Very important, but we do have to understand, I think it's important that we understand, when things go awry, where do they go awry? And where they go awry is very frequently in terms of the goals we write. So, let me just talk about this little girl for a minute. You may recognize this person. This little girl is named Amy Rowley. Amy Rowley was the subject of the first Supreme Court case ever heard in special ed. 1982, Board of Education of the Henrik Hudson School District in Montrose, New York versus Rowley. And Amy Rowley was deaf, and her parents, and she was one of the very first students ever to attend her elementary school who had a disability. Her elementary school was Furnace Woods Elementary, and she attended the school. And they were very excited about getting their first child with a disability in the public schools. This brand new law had been passed, and they did a really good job of meeting her needs. The IEP team met before she started kindergarten, and they had all these different things. They were going to do speech and language tutoring, and they were going to have a study hall. They had a really good program put together. But the parents said, and they were deaf too. They were profoundly deaf, both parents, which is unusual. And they said, well, this is really good, but what we'd really like also is a sign language interpreter for Amy. Once she gets into 3rd grade, as we know, things get a lot more difficult in terms of academics. And if she doesn't have a sign language interpreter, she will have a very difficult time. And we believe this new law requires you, school district, to provide a sign language interpreter because our daughter cannot meet her maximum potential in learning unless she has one. Well, the school district, to make a long story short, decided no. Amy's parents went to due process hearing. At the time, it was a Sec 2 level like we have in South Carolina. Wound up going to, after the state, it went to federal court, district court, U.S. District Court. Then it went to the Second Circuit Court of Appeals. Then it went all the way to the Supreme Court. And they said a number of things about FAPE. And one of the things they did in this case is the Supreme Court does this. They like to give a test. They like to instruct the lower courts how you're going to determine if a child is actually receiving a free, appropriate public education, or what we call a FAPE. And what they did is they developed a 2-part test. Now remember this, Supreme Court that's the law of the land. I mean, if they say something, every school district in America and the territories have to abide by it, because it's like passing a law. I mean, that is the law of the land. And they created this test to help lower courts and hearing officers to determine if school districts had, in fact, conferred a FAPE in their program. And remember what Robert Stafford said, the IEP is the baseline mechanism. So essentially what the Supreme Court was saying here is you have to look at the IEP, look at the actions the school district did, and you have to determine answers to 2 questions. Number 1 is, has the state complied with the procedures set forth in the law? There's a lot of different procedures, as you all know, that we have to follow in implementing an IEP. You know, we have to send out prior written notice, we have to notify parents of their procedural safeguards, schools have to do child find, they have to evaluate the assessment, there's all these procedures. So we have a ton of procedures we have to follow. And the Supreme Court said, you know, that's very important. We must determine, if we're determining a child's FAPE, did the state or the school district comply with the procedures of the law? The second thing they said is, after you determine that they did apply with the procedures of the law, we have to go to the second part, which is the IEP reasonably calculated to provide educational benefits? Did the child receive educational benefits? Well, now every lower court judge, circuit court, district court, every hearing officer, when we heard a FAPE case, we have to ask these 2 questions. Did the school follow the procedures, 1, and 2, did the IEP confer educational benefit? Okay, that's the end of that. Well, in fact, Rowley said, in the Rowley case, Supreme Court in the 6-3 decision said, school did a bang-up job of following the procedures. Everything was done excellently. When they got to the second part of the IEP, they said, well, Amy is not your typical special ed child. Yes, she was deaf and needed special ed. She also had an IQ of 140. She was a very bright little girl and was doing great in her class. Passed number 1. She was at the top of the class in kindergarten, went to 1st grade, and passing from grade to grade. And the Supreme Court said, well, this only applies to Amy, but how do we determine if her IEP was reasonably calculated to enable her to receive benefit? Well, she was the top in the class. She moved to first grade. Clearly, it must have been required. And then they said, but no, we're only talking about Amy here. Most kids with disabilities are not Amy with 140 IQ. So how you determine that differs for every individual child. So that was the end of that issue. Rowley was decided in favor of the school district. And I remember, I was in school at the time, and I remember people really worried that they could say the then PL 94 was unconstitutional. Well, they didn't, but they said this is what a FAPE is. Courts, hearing officers, you have to do these two questions. Well, that was never really a problem. The first part of the test, this part of the test, the procedural part of the test was never a problem. Courts had a real easy time with that. You just look at the law, and you look at how the school district enacted or got to the IEP table. Did they do child find? Did they notify the parents? Did they involve the parents? All those procedural things. It wasn't difficult for a court, a judge, or a hearing officer to say, here's what the school did, here's what the law required. Procedurally, they were fine. That was not a hard issue. The second issue was a real hard issue. When can a court or a hearing officer decide when an IEP is reasonably calculated to provide educational benefit? Well, one of the things Julie was just saying is judges don't like to do that because they're not experts. We're the experts. You folks are the experts. It's difficult for a federal judge, so they like to tend to throw it, but they tend not to like special ed cases a whole lot. And a lot of I can tell you from being in the state I'm in, a lot of due process hearing officers are attorneys, and they're not particularly up to date on special ed. So you can imagine how difficult it was for federal judges to determine when is an IEP reasonably calculated to provide benefit. So here's what we had a problem. We had a number of states, and they're illustrated in, we had circuits. Circuits are comprised of a number of contiguous states, and the circuit courts are right under the U.S. Supreme Court in terms of importance. We had three of them, the Fifth Circuit and the Third Circuit and the Sixth Circuit, saying they had a high standard. They said, basically, well, Congress would have never required millions of dollars to go to special ed if they wanted just any old benefit. They want meaningful benefit. So in the circuits in purple, they were saying for a school to actually meet the FAPE standards, not only they have to pass part one, the procedures, they have to pass part two, the substance, and we say schools in our circuits need to provide meaningful educational benefit. But then we had a bunch of other circuits, and like my circuit in the fourth, in yours, which is there in the seventh, Indiana, they decided on a low standard. They said, well, we do part one, we look at the procedures, we look at part two, and part two is the IEP reasonably calculated? And they said, well, reasonably calculated to provide educational benefit, in our mind, in the circuits in the green, is a lower standard. They use like good, some if a child receives some benefit, they receive an appropriate education. And one of these cases was in the middle of the 10th Circuit, Colorado. It was a case called Endrew F v. Douglas County School District. This was a case involving a little boy who had autism, and this was the school he attended. It was called Summit View Elementary. And these pictures were taken by my friend called David Bateman when he was in Colorado. And he had been there for 4 years, pre-K, first, second, and third, and kindergarten. And when he entered fourth grade, the parents said, Andrew is not, they called him Drew. Drew is not doing very well. He's really starting to misbehave. Academically, he's not making a lot of progress. And so, school, you need to really change the IEP. We want measurable goals that are ambitious, We want a behavior intervention plan based on a functional behavioral assessment. And the school district essentially said no. They didn't really say no, but what they did is they wrote an IEP, and one of the things in that IEP is many of the goals were from the previous year's IEPs. They just kept them from year to year. And they really didn't collect any information as to Endrew's progress. So what Drew's parents did is they pulled him out and put him in Firefly Autism House. And if I had put the whole picture up that David had sent, you'd see the Firefly Autism House was like the size of your basic Rambler you find in a subdivision. Real small, very expensive, 70 grand a year just for children with autism. They had an ABA therapist on staff. They had BCBA trained teachers. They had teachers who, if there's anything ABA does, they collect data. And they had good measurable goals. They collected data. Drew did very well. He did very well in his 4th grade year. At the beginning of 5th grade, his parents went back to the school district and they said, we really want Drew to attend public schools. So here's the IEP head. Let's write a new IEP for him that uses good behavioral program, that has these really good goals. And they collect data. And the school district said, yeah, absolutely, we will do that. And they wrote an IEP that contained the same goals as the previous IEP. In other words, they didn't do much of anything. So the parents went back to Firefly, put Drew in Firefly Autism House, and they requested a due process hearing. But when it went through due process hearing, the school district won. Why? Because, remember, they used this real low standard. And believe it or not, this is what the standard was. The educational benefit mandated by the idea must merely be more than de minimis. De minimis, when used legally, is a term it's so minor an issue or trivial an issue, court doesn't have to pay attention to it. So essentially, their standard was that if you show any progress at all, that's good enough to meet the FAPE standard. And that's when the parents said, well, no, that's not right. But it went through the due process hearing officer. He had to use that standard in determining if the IEP was reasonably calculated to provide educational benefit. Went to the U.S. District Court. That judge had to use this standard, a man named Louis Babcock. He had to use this standard. He decided in favor of the school district and also wrote, boy, the school didn't do that great a job, but there's some evidence that Drew did make progress at some point a couple years ago. Therefore, they met the standard. Went to the U.S. Circuit Court of Appeals for the 10th Circuit, and they're the ones that came up with that. Well, clearly the school district wins because the education we provide has to be merely more than de minimis. And actually, this terminology came from merely more than de minimis, came from a 10th Circuit Court decision decided before that, written by Neil Gorsuch, who's now in the Supreme Court. Well, what happened is the parents, undaunted, they had lost hearings, they had lost federal district court, they had lost in the Circuit Court of Appeals, they decided to exercise their last appeal. And that appeal is to the U.S. Supreme Court, last court in the land. Thing is, Supreme Court maybe hears, well, they don't hear many cases. They'll hear 80 cases probably out of 60,000 a year that are appealed to them. They don't hear many appeals. In fact, they don't even, and they don't tell you why, they just don't hear them. Well, lo and behold, this was a question presented by the attorneys for Endrew's parents. Their question was, what exactly is the educational benefit mandated by the idea in order that school districts provide a FAPE? In other words, they didn't agree with this low level of educational benefit. So they asked the Supreme Court, clear this up for us. What exactly do you mean by educational benefit? Well, to the surprise of many, on January, or in late December actually, the Supreme Court decided to hear the case. They put it on the docket. They agreed to answer this question. So on January 11th, the attorneys for both sides presented oral arguments. Remember, the one question the Supreme Court is trying to answer is, what is the level of educational benefit due to youngsters with disabilities? Now, normally there's 9 people on the Supreme Court, 9 justices. There's only 8 because, of course, Anton Scalia had passed away, and they had obviously not appointed a new justice, so there was only 8 justices. Now, if they had come with a split decision, and these are generally considered the conservative and they're more progressive, if it had been a 4-4 ruling, it would be like nothing ever happened. The 10th Circuit would have prevailed their decision. But that's not what happened at all. In this case, and it's an amazing decision, look it up sometime, and I have the reference. It's a 16-page decision written by Chief Justice Roberts, and it's really a good decision. And he says right at the outset, this case puts the question to us, what is educational benefit? And they decided, well, it's sure a lot more than de minimis, which is a standard you used, or your circuit court used in the 7th Circuit, and we used in the 4th Circuit. So what they did is they did something called vacating and remanding the decision. They said, this is no longer good law. It's over. Forget it. But we're not going to decide it. You 10th Circuit, we're going to kick it back to you, and you decide what it is. And we need to develop a clearer way to measure educational benefit. And one of the things they said in the decision, and actually in the oral arguments, because both David and I were fortunate enough to be at the oral arguments, is they said, we don't put a lot of stock in this educational benefit because everybody's confused. We've got to come up with a way to make it clear what is FAPE, what is the educational benefit under FAPE. And they said, to meet its substantive obligation under the idea, a school must offer an IEP reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. So in other words, they got rid of educational benefit. In fact, let's see if I have a slide here. I think I do. Yeah, we have really a new 2-part test. So this means every judge, every hearing officer, if you get a FAPE case, this is what you have to do. First thing you have to do is the old Rowley test. Did the school follow the procedures properly? That's why, so it's very important we understand, and as administrators and teachers, we all know what procedures we have to follow. Sometimes our general ed counterparts and principals may not, but we have to follow these procedures. But the second part of the law, which is from the Endrew case, got rid of the educational benefit standard. It now says progress appropriate in light of a child's circumstances. So in other words, what the Supreme Court is saying is you have to develop an IEP that enables a child to make progress. Progress is a much it's a clearer term than benefit. It means progress implies movement forward. Now, so what exactly does that mean? Well, one of the other speakers of this conference, who is virtual this year, named Perry Zurkel, wrote an article in 2017 where he said this: the substantive standard of the idea focuses on the content of the IEP and the likely or actual results of the IEP. So that's important. The IEP has to be written in such a way that it is likely to confer progress, or it actually confers progress on the child. And how do you show progress? That's the big question. Well, the lessons of Endrew F are this. If we want to show progress, we begin with a well-defined understanding of all of a child's needs. In other words, we do a thorough assessment of all of a child's needs. And where do we write that? In the present levels of academic achievement functional performance statement. That is the foundation of the IEP. There have been many cases that have shown, and hearings, that if we don't get that right, nothing else will be right after it. Why? Because that's the foundation. Everything's built upon the present level statement. Very important. We have to get that right. Then we have to write measurable annual goals and services that are going to address every one of those needs. And not this past due process hearing case I had, but the one before that. I looked at the IEP. One of the things I found is present levels had a statement of need in math, and nowhere else in the IEP was addressed. Well, that's an illegal IEP. Why? Because it's not addressing all the needs. If we think of the present level statement as the foundation of a house, you know, if your foundation's bad, it's likely the rest of the house is going to eventually have problems. That's the same way with our IEPs. We really need to concentrate on that. Then, from those, we have to write our measurable annual goals and or services that will address those needs. Now, we don't need a measurable annual goal for every service. Some needs, say a child has a need for large print books, well, you don't write a measurable goal for that. You have to have a service where that's provided, but you wouldn't necessarily have a measurable goal. But when we're looking at behavior, instructional needs, we need goals. And if we don't have goals that are measurable, how can we measure them? We can't. And that's a problem that I and David, who has done 500 some hearings, have seen so often, is goals are just not measurable. And it's not that teachers don't want to write goals that are measurable, it's they're unsure how to do that in a way that is actually legally correct. And then, of course, we have to measure progress. And as I'll say, in the last 2 hearings I've had, and when I've done the expert witness, that's the first thing the attorneys have looked at is, was that goal measurable, and did they actually collect data that showed progress? And they all go back to, what does Endrew say? It says we have to show progress appropriate. If we don't have some kind of data to show progress, well, we probably have an IEP that does not confer fate. So the question then is really, well, how do our IEPs, do they have to look different now that the Endrew decision has come down? No. They have to look the way they've always looked. Your IEP answers 4 basic questions. Number 1 is, what are all those needs that the child has that you're going to use as the present level statement that addresses where you can have a present level statement that addresses all those needs, which of course means we have to have a thorough and full assessment of the child so we can identify all those disability-related needs. 2, we have to write goals and objectives. Most states still require objectives in their IEP. In all states, they have to have objectives for youngsters who take alternate assessments that enable the student to achieve meaningful educational benefit, although now we could say more accurately, progress appropriate, that write goals and objectives that will enable the student to make progress appropriate in light of his or her circumstances. 3rd, we have to have services that will deliver a thorough education that will address all of those needs. We have clearly if we have a goal, we have to have a service addressed. If we have a need, we have to have a service addressed to it. And then finally, how are we going to monitor the child's progress? Now, in terms of goals, when I started back the days of PL 94-142, goals had to be goals. In 1990 and 1997, it was changed to measurable annual goals, that the goals have to be measurable. So that was a difference there. But those are the 4 basic questions we have to answer in an IEP. So essentially, the IEP process looks like this. Step 1, get your present level statement down, addressing all of a child's needs. Step 2, write your measurable goals and objectives. Only the actual goals have to be written in measurable terms, but best the objectives too. 3, you determine, well, what services are we going to provide so that the child will make progress appropriate in light of his or her needs, and 4, how are we going to monitor the student's progress. So in a way, you can't really separate these different steps because they're all required in the IEP process. So what I'm going to do is talk a little about this and a whole lot about that and just a little bit about that. So now the components are, okay, so think of it like this. This is our foundation, our present levels of academic achievement, functional performance statement. Then, based on that, the needs statement for all instructional and functional behavioral areas. And by the way, goals have to be behavioral or functional as well as academic. And so academic achievement and functional performance. Congress really emphasized the importance that we're not only about academics, we also have to address functional issues. Based on that, let's say we have an assessment that shows a reading need. Well, we write our annual goal. That's a 1-year projection of what we want the child to, where we want the child to go. And so these little marks here would reflect monitoring progress. So what the idea says, and of course as Matt has told folks many times in trainings, you need to measure progress in a formative way. That is, you don't just measure progress at the beginning of the year and then the end of the year. You have to measure it during the year. That's what those little arrows represent. And you can measure as much as you want, but you have to understand what your district, what your state says in terms of how often you have to monitor progress toward your annual goals. But Article 7 and the idea have that language in there about, for example, this should be as often as general ed students receive report cards. So it's on a formative basis, because if you don't do it during the course of the year, you won't have any information to make a decision based on is the child meeting their goal or not. And then, of course, the special ed services are really, these are the different things we do. Special ed services, related services, supplementary services, progress monitoring, all those kind of issues. Now, let's go back to step 1, the present levels of academic achievement, functional performance. This is what the law says these statements must do. They must identify the student's need, all disability-related needs. They must identify what the effect on general education is. They should serve as a baseline and then be connected to a goal, service, or both. Now, let me talk a little about the third. Present levels essentially serve as a baseline. That's where the child begins. If you don't have it, courts have not said it has to be a baseline statement, but if it's not, how are you going to measure progress? Because you have to be able to compare the child, where the child is, to where the child was. And so it has to be a baseline statement. Now, the next thing was, so in a graphic format, it would look like this. If we decide the child is here, that's our baseline. So this is actually a graph taken from one of our school districts in Greenville, South Carolina, where's the upstate, where they use curriculum-based measurement. They use oral reading fluency measures. This child was they did 3 different measures, and the child had a median of 44. So that's the baseline. 44 is where the child begins. Now, in terms of the third part, or the final part I had in the graph, is the connection between all these pieces of the IEP. This is from Appendix A to the IDEA regulations, written back in 1997. And it said there should be a direct relationship between the present levels of performance and the other components of the IEP. Thus, if the statement describes a problem with the child's reading level and points to a deficiency in reading skills in the present level statement, or the PLA-AFP statement, the problem should be addressed under both goals and specific special education-related services provided to the child. This was written by the U.S. Department of Education in a question and answer document in 1997. That was question 36, is how does the present level statement align with the rest of the IEP? And that's essentially it said it informs the whole IEP process. So that's very important. And in writing measurable goals, clearly we have to have a good place to start, and this is where we start. Okay, now measurable annual goals. This was the language on measurable goals was actually changed, the idea, in 2004, and it said goals should address the areas that meet a student's academic and functional needs arising from his or her disability. So academic and functional was given a big part. So actually the name of present levels was changed to present levels of academic achievement and functional performance. The goals, if you read the section on goals, it talks about academic and functional goals. If the child needs them, if the present levels have identified functional goals, we also have those. And what are functional goals? Well, the idea, in court cases, it never really said what exactly functional goals are, but they've said it's anything the child needs to succeed in life as an independent learner outside of academic achievement. Communication, socialization, behavior, those kind of issues too. Also, goals should be directed at meeting those present levels of performance statement. So they need to be directed at meeting the student's needs related to the disability so he or she may be involved in general education. What that does not mean is goals have to be taken from state's academic achievement standards or whatever the state may have. You still individualize them, but you keep in mind what they need to perform in general education. Now, how do we, and of course the big thing since 1990, 1997 is this, measurable. How do we ensure that our goals are measurable? Well, when I went to school back a long time ago at the University of Minnesota, I got an undergraduate degree in education, and my area was social studies, political science, and history, and I had a professor by the name of Edith West. And what she did is she required everybody to write lesson plans, social studies lesson plans, and every lesson plan had to begin with what she called an instructional objective. And she had us purchase a little book called Preparing Instructional Objectives. This book was actually written by a fellow named Roger Mager in about 1958 or so. It was published in 1960. Very interesting fellow. He had been an efficiency expert for the United States Air Force. In fact, when I did a presentation once in Florence County 1, which is a district in the middle of South, well, not in the middle, it's toward the eastern part of South Carolina, and a fellow came up to me during the break And he said, I knew Roger Major when I was in the Air Force. He was an efficiency expert. He did things like try to figure out how people could be most efficient in doing their jobs. The Air Force is very interested in efficiency. And he came up with this system to increase efficiency, where he said, we need to have objectives for every, if it's greasing Jeeps or repairing motors and tanks, we need to have objectives. And so he developed this system where all these different agencies within the Air Force developed objectives for these different jobs folks did. And then when he retired from the Air Force, somebody said, well, this would be a good way to write goals, educational goals. Now, this was before any 94-142. It was in the late 50s. And he said, you might want to think about taking your system and applying it to education, developing goals. So he wrote a book back in 1960 called Preparing Instructional Objectives. And you can't read this, but it says a book for teachers and student teachers for anyone interested in transmitting skills and knowledge to others. Well, Dr. West made us use this book. And you can't see it, but this is the original book, and the price was $2.80. So you can't buy it anymore for $2.80. You can find it, the third edition actually, on Amazon. I think it's like $18. But what he developed is a perfect three-step way to write measurable goals. I mean, if you follow his system, you can't help but write a measurable annual goal. And like I said, there was three parts of it. And I'm going to get into that in a second, but let me just show you overall what he said. Roger Major said you have to have three things to make a goal measurable. First, you have to list the target behavior. What is the target behavior? Well, the target behavior is what we want to change. It's from the needs statement in the present levels of academic achievement and functional performance. So the target behavior has to be something we can see, that we can count. The target behavior, for example, has to be measurable, has to be verifiable, has to be repeatable. So measurable means you have to be able to look at it and count it. So let's say, let me go back to that, what they did in Greenville. They used oral reading fluency measures for the present level statement. Well, oral reading fluency, asking a child to read to you for 1 minute, that is measurable. If all you have to do is count the words they read in a minute. That's measurable. Verifiable, that means somebody else can verify that very easily. And it has to be repeatable. So over and over again, we have to be able to do it and get a measure. So like to write, to read aloud, to point to, those are examples of good targeted behaviors. They're observable, they're measurable. Now, how about subjective target behaviors? These are anything that are open to a lot of interpretations, like to understand, to enjoy, to improve, to develop. Those are not, according to Major, good target behaviors. Why? You can't measure them. You can't unzip a kid to see if they're enjoying something or if they're understanding something. You can, however, count the number of words read aloud or count the number of assignments completed correctly or the degree of accuracy. So remember that. Target behaviors have to be observable. So when you look at your goals, ask yourself, are these goals, what's the target behavior first off? What are we looking to change? And when you find that, you ask yourself, can I observe that? If I, say you're an administrator, if I went into a class and watched the teacher, could I observe verify those types of behaviors. That's what Mager meant by target behaviors. The second thing he said, it's got to have a condition. He called it stimulus condition. A few years later, Barbara Bateman wrote a book in which she called that the given. And that's kind of an easy way to understand it. You know, given a story starter and 3 minutes to write, Johnny will write how many correct word sequences. That's an example of a given. Could be the materials, like I said, given a story starter, or maybe given a second grade reading text and asked to read aloud for 1 minute. A read aloud would be the target behavior, but given the first grade basal text, that would be the material, or it could be the environment while a child's at recess. But anyway, the second thing we have to have in is how the behavior will be measured. Okay? That's the second part of Mager's system. The third part is this. What's the criterion for acceptable performance? How do you know when it's mastered? So remember, we have to write our goals. They're 1-year goals, where the child is going to be after 1 year. We have to have that baseline. We talked about the present levels of performance, and then what will show us when the child has met that goal. Using that example, will the child be able to read 124 words correct per minute? Or will they be able to write 40 correct word sequences? Whatever it is, it has to be data. It can't be subjective opinion. It can't be something like, as measured by teacher observation. Because, and I'll show you this later, there was a court case a couple of court cases actually, one court case that threw goals out because the only data collected was by teacher observation. That was not specific enough. So the data can't be subjective. It can't be things like to be determined. It has to be stated in terms of how accurate we want the child to be, how fast we want them to be, the quality, say correct word sequences, or fluency. Those sorts of things are the criterion for acceptable performance. And again, they have to be measurable. They have to be verifiable. Let me give an example. This is an example of an annual goal, and this was also taken by from an IEP written in Greenville, South Carolina. In 32 weeks, when presented with a passage from the second grade reading text, Jeremy will read aloud 48 words a minute with less than 2 errors. So does it have all 3 parts? Well, first off, does it have a target behavior that's verifiable, measurable? Yes. Read aloud. That's target behavior. Now it has to have a stimulus or a given, a stimulus condition or given. How are you going to measure it? When presented with a passage from the second grade reading text. That's how you measure it. You give Jeremy the reading text, you ask him to read for a minute, and what's the criterion for acceptable performance? 48 words per minute with less than 2 errors. That's how they measured it. That was the criterion for mastery, or the criterion for acceptable performance. Okay, now in South Carolina, we have to put another element. We have to put the time in our IEPs. How long? In 32 weeks. His IEP was written at the end of the year, was 32 weeks, so that was included in the particular annual goal. And notice, I mean, this isn't the method, it's a method. Mager's method is a method, but if you don't have those 3 things, I'm not sure how you're going to write a measurable goal. If you don't have the target behavior, you don't have how you're going to measure it, and you don't have the criterion for acceptable performance. Now I'm just going to give you a couple examples here, and these are from different IEPs, but in letter names. In 36 weeks, when given a page of 100 upper and lowercase alphabet letters in mixed order, Nick will increase correctly naming the letters in 1 minute from 28 to 68. That's about letter naming. Are all the 3 things there? Absolutely. Nick is going to increase his correctly naming. How are they going to do it? What's the given? When given a page of 100 upper and lowercase alphabet letters in mixed order or random order. And what's the criterion for acceptable performance? Correctly naming letters in 1 minute from 28 per minute baseline to 68. Now, in this particular one, they not only added the time in 36 weeks, but they added the baseline. Because he was at 28 words per minute, or letter names per minute, when the present level statement was done. And so they put the baseline and where he's going to be. Perfectly acceptable, but you know, it's got those 3 elements. It's got the target behavior, it's got the given, it's got the criterion for acceptable performance. Another one, math. Given a page of 28 addition and subtraction problems from 1 to 3 digits without regrouping. What is that? Is that the given, the target behavior, or the criterion? That's the given. The given is in green. So that's how you're going to measure. You're going to give them a page of 28 addition subtraction problems from 1 to 3 digits without regrouping. Alex will increase the number of correct digits written. That's the target behavior. You're writing it. It's measurable. In 2 minutes from 24 to 76 by May 2020. And that has obviously the name of the student, it's got a baseline as well as a criterion, and it's got a time limit. So that's an example of a goal that added to, but it still has target behavior, condition, criterion for acceptable performance. Now, writing. Let's look at this one. Given a story starter in 1 minute to think, that is our given. You're giving little Amelia a story starter and saying, okay, think for 3 minutes, Amelia, what are you going to write? And she thinks for 3 minutes, and 1 minute, I mean. Amelia will increase the number of correct writing sequences. And this is like from one of our school districts that uses curriculum-based measurement. So one of the ways you measure writing is correct writing sequences. Do the words next to each other make sense? Completed in 3 minutes from 14 to 37 by the annual review date of this IEP. So we have extras here. We have her name, we have the baseline, we have the timeline by the review date of this IEP, but we also have the 3 things. We have the target behavior, will increase the number of correct writing sequences, the given a story starter in 1 minute to think, and then we have the criterion for acceptable performance, which is actually 37. So you see, you have this goal has extra stuff, but it also has Mager's 3 points in it. Reading by June 2020, when given a 6th grade reading passage, Ellie will increase the number of correct words read aloud in 1 minute from 120 to 157. All 3 things. Given, when given a 6th grade reading passage, target behavior, read aloud, criterion for increase the number of words, and 157 is the actual criteria. So you see, even the goals can differ. They can add extra stuff, but they need those 3 elements, Mager's 3 elements, to truly be measurable. Now, just a couple more. There's comprehension. Given May's passage at the 9th grade reading level, Brad will increase the number of correct word choices made from 14 to 30 in 36 weeks. All 3 elements. Functional. Given the direction to clean up and a task analysis of 17 steps. That's the given. Teachers, this was a child with a more severe disability. And they actually did task analysis of cleaning up. Given the direction to clean up and a task analysis of 17 steps, Dan will increase the number of steps completed, that's the target behavior, independently from 517 to 717 over 3 consecutive days by the annual review date. And here's an example of behavior. One of the things, In terms of behavior, given 8 independent seat work assignments to complete each day, that's our given. Mike will increase the number of correctly completed assignments, that's our target behavior, from 3 to 7 for 3 consecutive days by the annual review date of the IEP. So that's a behavior one. One of the very important things about measurable annual goals is you really want to make them, crouch them in the data collection in terms of what teachers do every day. You know, I remember going through classes in which we were taught things like momentary time sampling and things like that. Teachers aren't going to do that. That's too difficult. That is not in their daily practice. Giving them a worksheet, giving them a seat word assignment, that's something you do every day. Maybe having a child to read. So our measurable goals should be something we know that we will do. Because believe me, when it gets to a due process hearing, that's one of the things they check on, that data. Can I see your data? And you know what the Endrew decision said about measuring progress? Hearing officers, and I'll talk more about this a little bit later, can expect a cogent and responsive explanation from the teachers or the administrators of why this actually means the child will make progress. Well, one thing you can do is say, well, we have the data sheet here that shows it. That's your perfect response to that. Now, so in terms of measurable annual goals, I want you to remember target behavior. You have to have it. It has to be verifiable, repeatable, measurable. Conditions are given. That's how it will be measured. Third, criterion for acceptable performance. And our goals are for 1 year. I always say, put in the timeline. You know, some states, like South Carolina, they require that we actually put in the baselines. So, and that's all fine. Just remember to have these first 3 points, or you don't have a measurable annual goal. So think of this as kind of a checklist. Number 1, are goals linked to assessment and the present levels of performance statement? Are they specific, clear, and measurable? I know you probably all heard that acronym that actually came from business, that our goals should be SMART. They should be S for, I don't know if I put that down here. S for specific, M for measurable, A for ambitious. I like to say ambitious but reasonable, so reasonable is our R, and T is timeline, or time-bound, SMART goals. A very important thing to remember is that goals should be ambitious. Because remember, the Endrew standard says progress appropriate. So I've often gotten this when I've talked to people. They say, well, why don't we just make goals so easy we know kids can make them? That's the wrong answer. You know why? Because goals that are, and I'll show you a decision about this in a little while, that are so unambitious that kids make them doesn't make a difference, that will not pass legal muster. I mean, the Supreme Court said every child has an opportunity, must have an opportunity to achieve ambitious goals. So they should be ambitious. You know, schools don't lose because their goals are not schools don't lose FAPE cases because they write goals that are too ambitious. They're more likely to lose them if they write goals that are not ambitious enough. So err on the side of ambition. Always remember your IEP has to contain information on how progress will be communicated to parents. You know, and by the way, we were talking way back about the procedural elements. That's the most important procedural requirement of the IDEA, is that parents be involved. In fact, the Ninth Circuit Court of Appeals called that the essence of IDEA, that parents have to be involved. Is the goals progress toward goals actually measured? If you write down goals, if there are goals in your IEPs, you need to measure them. You need to have data. Because like I've been an expert witness in 2 cases in the last 4 months, and one of the first things the attorney for the parents honed in on was, show me your data. Hey, that's okay. Supreme Court said that's okay. They would say, show me the data logs that the teacher collected. Well, we don't have them. Uh-oh. That's a problem. So if you have measurable annual goals, make sure you measure them and provide that information to students' parents. Just a few things, cautions. These are from court cases. This was from Endrew, well, I put a quote from Endrew F, but the actual case was out of South Carolina. It's a case called Carter v. Florence County 4, wound up in the Supreme Court. Cost the school district $2 million. Started out at the IEP table, and what happened? They wrote goals that the court said are unambitious. They're worthless, because if the child meets them, well, this is what they said. The stated progress on Shannon's goals in reading and math skills for an entire school year ensured the inadequacy of the IEP's inadequacy from its inception. Even if Shannon had met her goals, she would continue to fall further behind her peers. The goals were wholly inadequate. Florence County School District failed to provide Shannon Carter with a free, appropriate public education because the goals were so unambitious that if Shannon had met them, it would not have been for her. Shannon was a 9th grade student who her parents, her mother actually, was part of the IEP team. She was in 9th grade. The school district's IEP goals called for her to make a quarter of a year's progress on a standardized assessment device in 1 year's time. So in other words, 0.4 year of growth for every year. Court said that's inadequate. Shannon can, you have to consider the child's capabilities, but they said that's inadequate from inception. So don't worry about writing goals that are too ambitious. Like I said, make them reasonable, but err on the side of ambition. Remember, from Endrew F, this is one of my favorite quotes from that decision. The essential function of an IEP is to set out a plan for pursuing academic and functional advancement. So you want your goals to be ambitious. Goals that are not measurable, that's a big no-no. Watch out for that. A goal which called for a student to develop writing skills by monitoring usage of rubrics provided in class was not measurable and was not verifiable. So if you're going to say teacher observation, if you have some sort of data checklist that you're using, or speech and language clinicians often, they have to, if they're working in articulation, they have to listen to the child articulating sounds. Obviously, that requires some amount of observation, but they need to have some kind of checklist to show that they're really doing it in a systematic manner. So systematically consider the words you use in the goals and make sure you can measure them. And think of this, if you can't graph it, it's probably not measurable. So if it's completing independent worksheets, doing a task analysis, making certain speech sounds, reading words aloud correctly, you have to be able to put the baseline in a graph and where you want the kid to go. If you can't do that, you probably don't have a measurable goal. Here's another one. This was on a case out of New Mexico. It was a state educational agency decision. 2 years of IEPs were overturned, were decided by the state not to provide FAPE, because the students' annual goals and objectives in each IEP simply do not contain objective criteria which permit measurement of student progress, a goal of increasing reading comprehension, and they had a goal of improving decoding skills. Well, maybe good goals, but they didn't say what, improving to what, or increasing to what. So that was obviously inaccurate. Even if present levels of performance were clearly stated, an open-ended statement that the student will improve does not meet the requirement for a measurable goal. Now, this was after goals were required to be measurable, but way before Endrew that required progress. So we should think of measurable annual goals could pass the stranger test. You could get a stranger in there, and they could read the goal, and they could understand what exactly you mean. Misuse of percentages. So many IEPs really misuse percentages. And the Rio Rancho had a good example of that. Annual goals that contain percentage of accuracy is not helpful where the IEP fails to define a starting point, an ending point, or the curriculum in which a student will achieve 80 to 85% accuracy. So what they did, what these IEPs, what these goals said in this particular case were Jeremy will increase or will improve decoding to 85% accuracy. But it didn't have a starting point. So it didn't make any sense. Or, you know, I mean, if you have completing numbers of problems, certainly use percentage, but also have a baseline or have it make sense. Because a percentage by itself doesn't make a lot of sense. They're pretty much meaningless. So if we had a picture of this, it would look like this. If we took that graph from the Greenville that we did earlier, they had a 44. They decided, this was an oral reading fluency measure. They had 88, was it 89 was the goal. That's what they decided. And there are, I mean, you can go on many websites like, free websites like easycbm.com, and you can find national norms for things like oral reading fluency or writing math tests or those sorts of things. You can find that. They took it probably off easycbm.com, figured that 89 would be the annual goal, so that, remember, you have to be able to graph it. If you can't graph it, it's not a measurable goal. There's where their goal was. Then there's a line, kind of a trend line we want from here to there by the end of the year, and of course, they measured it. That would be what you call your goal line. You want the child to be about there. So if they're like reading down here, you're thinking, oh, this is what we're doing is not working. So what do? You're making some sort of change to instruction. You might change the services. But we have our goal line, and what they do in the school district is they'll collect data. So they'll have a lot of little marks during the year. And they report to parents. They show parents the graph. You can do this graph with any type of measurable goal. And that would be the perfect evidence to present a due process hearing officer. Now, in terms of measuring student progress, we've talked about this, so don't need to talk a lot about it at all. But we also, in the IEP, you have to include there how you're going to measure the student's progress toward the annual goals and how you're going to report it to parents. And of course, what I have in the parentheses there is from the idea of federal law, such as through the use of quarterly or other periodic reports concurrent with the issuance of report cards. That was actually in 1997, was a requirement. Now it's just an example. So it's just an example of a way you can do it. But here's something the U.S. Department of Education said about measuring goals. Effective teachers use data to make informed decisions about the effectiveness of particular instructional strategy or programs. A critical hallmark of appropriate progress, of appropriate instruction is the data documenting a child's progress, that a child's progress are systematically collected and analyzed. I forgot a word there. So that was from the Federal Register in 2006. That was from before the Endrew decision, which obviously really requires that now. Now, our progress monitoring questions are basically because we need to have a database method of monitoring student progress. It's really important. That is essential that we do collect data to monitor students' progress. So you need to ask yourself, how will a student, in the IEP team, okay, now how are we going to monitor the student's progress? How are we going to measure progress toward the annual goals? What data collection method will we use? And remember, we want to use some sort of method that's easy, that's part of a teacher's daily routine. We don't want to put in something like momentary time sampling that's just kind of crazy and people aren't going to do it anyway. Do something that teachers will do. And that's part of your daily teaching. And then you determine how you're going to measure and report that to the child's parents. This is a kind of a graph. So your goals, this is sort of a methods which IEP teams could monitor increase in student achievement. That's what our formative evaluation is. Must be graphed, measured systematically and frequently, user-friendly, time-efficient. You want to make goal collection a part of the daily process. And then you have to use it. Of course, if your data shows the child is not making progress, what are you going to do about it? That's where Julie Weatherly would say, well, reconvene the IEP team. Decide, okay, here's what's happening. Child not making progress. We need to do something. That is important. If you can show, and I can show you many cases in which data, anecdotal logs were kept during IEP teams that discussed what went on in the IEP. And if they're meeting and they're saying, what's this annual goal? Child's not making it. What can we do? That goes a long way to showing that you're really making some big, good faith efforts. I wanted to just show you this real quickly. Kathleen Mayfed, she was actually retired last year. She was an attorney, just exclusively represented school districts in IEP FAPE cases. She said, when I have a school district with a FAPE case, the first thing I do is go to the teacher and say, give me information about your student's progress. If the teacher doesn't have data, I strongly consider advising the school district to get it out of the way, just settle it. Because that's what parents' attorneys are going to go for. They're going to go for the data that you've collected. This example of the goal of data that's collected in this IEP. Obviously, there was a bunch of goals. They were collecting data before the goal line. IEP team came up with a new plan, changed the service. I think if I remember correctly, they increased the amount of reading per day and continued to collect data. Look what happened. Now, that is, you cannot show that to a hearing officer and they would say anything less than, man, this school district is doing their job. They're really collecting data and they're monitoring the child's progress. That's what our job is. Remember, our job, IEP does not guarantee success. It doesn't guarantee a child's going to meet the goals. It guarantees we're going to make good faith efforts and do the best job that we can. Last thing, I have a couple of other things, but remember our IEPs, above all, must be internally consistent. We have to have the present levels. That has to lead to a service. Doesn't always have to lead to a goal, but if it's instructional or functional skills, then there will be a goal, and you have to have your monitoring progress. All those things have to fit together, and if they don't, you probably have an IEP that doesn't provide FAPE. So in terms of data collection, take good data, but make certain it's part of what teachers do, what you do as a teacher every day. Don't make it something extra you have to do. Just put it in with your daily routine. Analyze the data and respond to it. If your data is showing the child's doing great, fabulous. If it's showing the child is not doing very well, you need to make a change. So, we talked about all this. I have a number of resources that are online that you can refer to. Really excellent. There's a number of centers, and I haven't been, I put 3 of them down here that the Office of Special Ed program has. One's called the Progress Center. Actually, 3 of your speakers, me and David Bateman and Perry Zirkel, are on the Progress Center staff, and that's all about writing IEPs. That's cool. Look at that website, monitoringprogress.org. Excellent. Another one's the Intensive Intervention Center, and then I just have some other stuff on IEP modules and things like that that are very useful. But I would say, if anything, look at those centers, especially the Progress Center. Really good information for developing IEPs. Okay, we only have 5 minutes left. I thought we'd spend 10 minutes, questions and answers, obviously, but we don't have 10 minutes left, so does anybody have any questions for the last few minutes? Or queries? Okay. Let me go back here just because we have time. I want you to be able to think of your IEPs in terms of a checklist. You know, all involved staff must understand what they need to do. Do you remember when Julie was talking about Doe v. Withers? With the social studies teacher said, I don't care what you do, what you wrote in the IEP, I'm going to do it the way I always do it, and wound up being sued and paid, I think, $25,000, something like that, because he was sued under a law. But you need to make sure, if you have, especially you high school teachers, and I know I've done this, you need to make certain that everybody knows what they're substantive, what they need to do. So if you have program modifications like tests being read to children, you check with all your teachers and make sure they do that. One thing you can do is, you know, give them a real easy kind of cheat sheet or implementation log to remind them that you have to read the test. Because if your general ed teachers don't do what the IEP says, they could be in have problems. But certainly, if it ever goes to hearing, the school will have problems. Perform meaningful, relevant assessments of all of the students' needs. That's present, and include those needs in the present levels of performance statement. That is your baseline for your IEP. Everything flows from that. It's the foundation. Craft ambitious and measurable goals. If you hear in an IEP meeting, we don't want to make them too ambitious so the child doesn't make them. That's not the problem. It's not the child doesn't make a goal that could be a problem. The problem comes in when you don't collect data and you don't try to do anything. Remember, IEP is not a guarantee of success. It's a guarantee that we're going to make these good faith efforts. We're going to do what the law says. Ensure that all needs identified, have a corresponding service, accommodations, modifications, and then monitor students' progress and make changes when needed. Okay, that's all I wanted to talk about today. But let me just emphasize again, every hearing I've been in, as an expert witness, parents' attorneys have always gone off after the school data's, the data that the school district collects. So write your measurable goals in ways that will be part of a teacher's everyday activities and make certain you collect the data. So I just was reading a case last night where a school district used a system wrote in their IEP a system called Check and Connect, you may have heard of, where the teacher is supposed to fill out these forms every day. You check, did they do this? And it's usually based around the child's goals. Well, that was written in the IEP. They didn't do it. Or maybe they did it, but they didn't have these goals. They didn't keep the data sheets. Bang, they were clobbered because of that. So if you're going to say, if you say you're going to do it, make certain that you do it. Okay, that's all I want to talk about. By the way, my email is on the very first slide here, and I'll be happy to, myell@sc.edu. I'll be happy to answer any questions or any make comments. I know Matt and his crew, they know all this stuff. They're the folks to go to about measurable goals and collecting data. So thanks so much. Thank you.